Good afternoon. Welcome everyone to PilieroMazza's webinar on demystifying security clearances. We have this friendly disclaimer. As a law firm, we do have to offer disclaimers whenever possible. My name is Megan Connor. I'm here with my colleague, Michelle. Michelle, you want to say hello?
Good afternoon.
And we will be conducting the webinar today. This is some information about the firm, how you can receive information that we offer, including our newsletters, blog. We even have Twitter, YouTube. It's all available here. And here's an overview of what we'll be discussing today. Our goal is just to, kind of speak broadly about security clearances, both personal security clearances and facility security clearances. We'll take Q&A at the end, but if you have any questions as we go along, please feel free to submit them. We can see them on our screens here, and to the extent that we're able to address them during the webinar, we will. So let's get started. Security clearances for contractors are obviously something that we all need to be mindful of. They're very common. About 20% of the clearance holders right now are government contractors, so it's not just for government employees. Contractor facilities are also cleared. 13,000 of them are cleared, and just in 2014, the Defense Security Services, DSS, issued approximately 1,300 new facility clearances. The DoD issues the vast majority of clearances. Other agencies have their own processes and procedures for doing so. This presentation will speak specifically to DoD and DSS clearances. The kind of the thoughts that go into these processes do overlap with other agencies that also issue clearances, but just keep that in mind, that when we're speaking about this process, we're speaking about it for DoD, since that's by and large where most of these clearances are coming from. The National Industrial Security Program was established in 1993, and it represented a partnership between the government and private industry to safeguard classified information. There are 4 tenets to the program. The idea is to achieve uniformity, to implement reciprocity among agencies, to eliminate duplicative or unnecessary requirements, and to achieve reductions in security costs. A major component of the program is the NISP, the NISP operating manual. I'm sure you've heard that term before, and we will refer to it throughout the presentation. There are 3 primary clearance levels: top secret, secret, and confidential. There are also additional designations: sensitive compartmented information, SCI. Oftentimes you'll see TS/SCI. That means top secret sensitive compartmented information. That type of information is sensitive because it's derived from sensitive intelligence sources, methods, or analytical processes. There's also a special access program designation, and that applies when security protocols are in place for highly classified information with special access restrictions. The level of clearance that you need depends by and large on the duties and responsibilities of a position, which is often dictated for contractors obviously by contractual needs. And the individual can access the classified information up to including the level of clearance that they hold, so long as they have a need to know. So secret can access up to secret, but cannot access top secret. Michelle is going to discuss personal security clearance and provide more details on those.
And we have received a question. Someone is having problems hearing through the website. You can call in to the phone number that was provided in your registration email, and you should be able to hear the audio by using that. Although if you can't hear the website, you can't hear me say that right now. But hopefully everyone can hear us. Oh, and before I begin this part of the presentation, please apologize my voice. I have a bit of a cold right now. It's that time of year, as I'm sure many of you know. Okay, so beginning with personal security clearances, or PCLs, the first thing that you need to know about is eligibility. And to be eligible, an individual must have a sponsor. That could be a cleared contractor or a government agency. Then PCLs are limited to the number of employees needed for operational efficiency. So if you have 5 employees working on a cleared contract, that's the number of clearances you could sponsor for your employees. And as part of that, you are not permitted to establish pools of cleared employees. To receive a clearance, you also must have a legitimate and present need to know. So your job must require access to classified information. And then the clearance you'll seek will be the level of classification that you need to perform that job. So if the contract involves top secret work, you'll need to get a top secret clearance. And then finally, in most cases, you must be a U.S. citizen. As noted here, there are exceptions in certain situations, but it's much more streamlined for U.S. citizens to get a clearance. So the first step in seeking your personal security clearance is the standard form 86. If any of you have dealt with this, you know it is a long and somewhat arduous process. It can take several hours to fill out. And here's the long list of the information that you need. Some of this is pretty straightforward. Some of it can be difficult if you move around a lot to know all of your addresses for the last 10 years. Luckily, if you use a lot of online shopping, sometimes you have those addresses stored. I know that was helpful to me in this process. Your schooling, 3 non-relatives who've known you for 7 years. Relatives, you have to list all of their names and addresses, former names if they've been married and whatnot. Any foreign contacts, foreign travel, foreign activities, anything significant in your psychological and emotional health. If you have a police record or a record of illegal use of drugs, problems with alcohol use, and your financial information is required, as well as involvement in court actions and any association you may have with groups that are involved with terrorism or overthrow of government or other radical type causes. And the requirements in the process for applying for a PCL vary somewhat depending on what level of classification you're seeking. For secret and confidential, there's a national agency check with a local agency check. In this process, the government may contact your references to verify the information you reported is correct. And there's also a credit check. Top secret is generally a more in-depth investigation. Often the government will interview references to verify the information you've been reported in the SF-86. I know I've met with the government before, and I've been asked if my friends have plotted to overthrow the government or if I know if they have a drug problem. I mean, pretty straightforward questions. The government's just double checking on your answers. And then in some cases, you may have to undergo a polygraph. And as Megan referenced, you can apply it to multiple agencies depending on who the work is for, and here we're focusing on the Department of Defense. And depending on the agency and the type of clearance you're seeking, it could take less than a month or it could take more than a year. CIA is pretty quick. They've processed all of their top secret applications in less than 8 months last year, and the majority in less than 4 months. And Department of State is even faster. It processed the majority of its applications in less time than all the other agencies. When the government is deciding whether to grant or deny a clearance, it's looking at for individuals whose personal and professional history affirmatively indicates loyalty to the United States, strength of character, trustworthiness, honesty, reliability, discretion, and sound judgment, as well as freedom from conflicting allegiances and potential for coercion, and willingness and ability to abide by regulations governing the use of classified information. And to make this determination, the government is going to look at the application, the investigation file, which would involve if it's contacted any of your references and done any interviews, and guidelines for eligibility. If the security clearance application is denied, the government must provide specific reasons in that notice of determination, which is called the Statement of Reasons. Now this slide 15, gives you a listing of all the different considerations that DoD is looking at when deciding whether to grant a clearance. As you may imagine, allegiance to the United States is one of the primary concerns, and in that end, it's related to foreign influence. And there, the government would be interested in any financial interests you might have, association with foreign persons, if you live near them, if they're your neighbor, if you socialize often with them, if you have a passport with another country, or you vote in another country, or you've taken advantage of benefits from other countries, such as education or health care. Those could all be red flags to the Department of Defense. For sexual behavior, the concern there is blackmail. It's depending on what kind of behavior is in question, what kind of representations you're making publicly. There's a concern that if someone were to find out you were doing something, they could use that for blackmail, and then you'd have a conflict of interest that could implicate your security clearance. Financial considerations, the concern there is that an individual may get into illegal acts to get more money. Gambling has been a problem for some people in getting clearances along those lines. Alcohol consumption and drug involvement are seen as indications of poor judgment or impulse control that may impact trustworthiness. For psychological conditions, once again, the government's looking at judgment control, potential blackmail. A formal diagnosis is not required. So if someone the government interviews suggests there could be a psychological condition, that could pose a red flag. Criminal conduct, that's pretty obvious why the government would be concerned about that. Handling protected information, the government wants to make sure that if you have a clearance, you're going to be able to guard that information properly. Outside activities goes back to the discussion about loyalty and overthrowing the government, terrorism, that type of thing. And use of information technology systems, with the increasing use of electronic systems, government wants to make sure that you're going to follow the right procedures for those things too. Now, it's important to recognize that the government uses a whole person concept, so a red flag is not necessarily a per se a clearance will be denied, but these are some of the things the government is looking at. If there are doubts, they will be resolved in favor of national security. Now, if a personal clearance, security clearance is denied, there's a process to appeal it. That process depends on the agency. At DoD, there's an administrative court-like hearing. In other agencies, there may be a first level in writing and then appealing in person, or starting out in person and then appealing in writing. The appeal process can take 6 months to 3 years. As I said, it begins with a statement of reasons that will list the issues identified, and then the applicant has the opportunity to answer the statement of reasons by admitting or denying, and in this line, mitigating any of the concerns raised can be very helpful. So here we have some example mitigating conditions. These are listed in the Department of Defense's adjudicative guidelines, and they vary depending on the perceived risk. For example, if there's a concern about allegiance to the United States, you could mitigate that condition by showing that you are unaware of unlawful aims of the individual organization that you were involved with, and that once you learned about that organization and the truth behind it, you severed ties with it. For a foreign preference, you could show a willingness to renounce dual citizenship or give up a foreign passport or disclose whenever you travel on a foreign passport. For financial considerations, if the problem was that you had bad credit, bad debt in the past, if you've shown that in recent years you've improved that and have shown a good faith effort to repay overdue creditors, that would be a mitigating condition that would help you obtain a clearance. And then finally here, their example is for drug abuse. If the behavior happened so long ago or was infrequent or happened under such circumstances that it's unlikely to reoccur, then it would probably cause less of a problem in getting a clearance. So in general, for these mitigating considerations, the government's going to be looking at the nature and extent and seriousness of any problems it identifies, the circumstances surrounding it, whether it was voluntary or knowledgeable, how frequent it happened, whether it was recent, when you were 17 or was it last month, and then whether you have continued to undertake that kind of conduct or whether you've changed your behavior, which feeds into whether it's likely to continue. So those are the possible ways to mitigate any red flags in your record. So if you are appealing the denial of your clearance in the hearing, this is a rough outline of the hearing process. You have an opportunity to present evidence. This is quite like a court proceeding almost, so it can be very helpful to have counsel here to help you marshal your case forward. You can present affidavits from your friends and colleagues or testimony from the same kind of people who will talk about your truthfulness and loyalty to the United States and discuss that you are a good candidate for a security clearance. If you're in a written, after the evidence is submitted, you can submit a brief, and there you'll want to lay out the Doha guidelines we talked about earlier and the mitigating conditions to show why the problems identified in the statement of reasons are not problematic. And Doha's decisions, the Department of Defense Office of Hearing and Appeals, is Doha, those are available online. So if you have time and are willing to do the research, you can go and look at those and find applicants that had similar situations and were granted clearances to help support your case. This is why considering retaining counsel can be helpful, because as lawyers, we're well trained in making these kinds of arguments. So then within DOD, if this initial appeal is denied, you can then appeal to the appeals board. You have 15 days to appeal that decision to the appeals board. The appeals board decision is final, and if your security clearance is denied by the appeal board, you cannot apply for a clearance for another year. This same type of hearing process applies if you have a clearance and it's revoked because of any problem the agency has identified while you had your clearance. Now I'm going to pass it back to Megan, who's going to discuss facility security clearance.
Thank you, Michelle. So when we're talking about facility clearances, I want to make a distinction that personal security clearances obviously go to a person. A facility security clearance goes to essentially the company and the office where the company operates out of. That's the facility that the facility clearance refers to. So oftentimes you'll see that contracts specify that the contractor must have a specified FCL clearance. And so that FCL speaks to what the contractor itself as the company has through what its facility is cleared to have. And facility clearances are tied to PCLs. A contractor can only have a facility clearance if it's, and we'll get into this a couple slides in, but it must have personnel that have personal clearances. So FCLs are tied to PCLs. And the process is similar. One of the big similarities is you need sponsorship. Just like you need a sponsor for a PCL, you need a sponsor for an FCL. That sponsor can be the government. It can be a prime. From what we've seen, generally, it's one of the best ways is to have a prime sponsor you, and then you have subcontracted work once you get the clearance, and you're performing, you build up your capacity to perform on these types of cleared contracts, and then you can use that as a past performance reference on a cleared contract in the future. And like the PCLs, as far as DoD is concerned, the FCLs are administered by DSS. The way it works is that your sponsor must submit a sponsorship letter to DSS. And the contractor, by the way, must have a CAGE code, a commercial and government entity code. You can get that from SAM. If you've registered with SAM, you have a CAGE code. And that CAGE code must be identified in your sponsorship letter. DSS on their website has a sample sponsorship letter that a sponsor can use. And I just want to take a minute to point out that the DSS website is a great resource. They go above and beyond to try to phrase things in a way that lay people can understand. And then they also, I'll speak in a couple slides about the handbook that they issue to contractors that are applying for the FCL. That handbook is also written in a way that is made to be easy to understand. So that's a great resource for you as you move forward in this process. DSS, in fact, will send, upon receipt of a sponsorship letter, DSS will send the contractor the FCL orientation handbook that I mentioned, and will then schedule a telephonic survey with the contractor. The survey will be with your FSO, your facility security officer, and an individual familiar with the business. That's what the requirement is, but this should obviously be your FSO and a top officer of the company. You will then have to upload required documents and forms to the electronic FCL system within 20 days after receipt of the handbook. These include some of your organizing documents, governing documents, and DSS will schedule a facility visit. You must at all points be familiar with the NISP. I mean, the NISP is really the Bible when it comes to FCLs. And you also, to maintain your FCL, need to enter the Defense Security Agreement, which is Form 441. It's an agreement between the contractor and the government outlining each party's roles and responsibilities with regards to the protection of sensitive information. So you have that sponsorship letter. What else do you need? You need to submit an SF-328, Certificate Pertaining to Foreign Interests. This is used to report your organization's foreign involvement, for instance, foreign ownership. I know that we've already received a couple FOCI questions, so we will touch on that in a couple slides. You want to create and implement your program in accordance with the NISP to make sure that there are measures in place to protect sensitive information. Your principal interface will be the DSS ISR, an individual, the industrial security representative. And as long as you have that security agreement in place, that DD 441, then your clearance will be effective. There will be annual inspections, and you must have a need for the clearance to be in place. So I touched on this to begin with, but the FCL is tied to your PCLs. So you need to have your FSO, who must be a U.S. citizen and must have trainings from DSS. That FSO must have a PCL at least the level to which the company is seeking an FCL. So if your FSO has a top secret clearance, then the contractor can also seek a top secret clearance. You must also have managers of classified business units. They must have the necessary level of PCL to which the business unit needs an FCL. And then your key management personnel all need to have the same level of clearance. And who qualifies for that key management personnel depends on the type of business structure that you have. For a privately held corporation, that would be a senior management official, your FSO, of course, chairman of the board, or vice chairman, and corporate officials. For an LLC, it would again be your senior management official, FSO, and then the members of the LLC who require access to the classified information and managers of the LLC. And for a sole proprietorship, it's the owner, the facility security officer, and the senior management official. Now, for a sole proprietorship, obviously the owner and the SMO are likely the same person, and by the way, that could also be the FSO as well. So when do you risk losing your FCL? If there's been a security violation, then your FCL could be terminated. A security violation could arise if you have failed to comply with policies and procedures, and there's a risk that classified information could be or has been compromised. NISP noncompliance could also give rise to a violation. That's why intimate knowledge and understanding of the NISP is so important. And when we deal with our clients who have clearances and they come to us with questions about the NISP and it is clear to us that they understand that manual inside and out, it gives us such a level of comfort because it's clear that they are taking their responsibility very seriously when it comes to maintaining their clearances and what they need to know. So potential consequences of a violation is obviously the loss of your clearance. Your cleared contracts or classified contracts could be terminated. Depending on the acts at issue, you could be suspended or debarred. The government may come after you for monetary damages, depending on the harm that the government has, undergone. And obviously there could be criminal penalties as well. So let's talk about foreign ownership, control, or influence, FOCI. A company is considered to be subject to FOCI when a foreign interest, and that can be a foreign government, a foreign company, a foreign person, has the power, whether it's actually exercised, whether it's direct power, whether it's indirect, but basically if they have the power to control the company and potentially access classified information to which they do not have authority to access, that can affect the ability of the contractor to receive a clearance and to maintain a clearance. So the purpose of that SF 328 with regards to foreign interest is to disclose to DSS any potential foreign ownership, control, or influence. It asks specifically about foreign ownership, foreign revenues, ownership of foreign revenues, non-U.S. board members, and foreign financing. Now, when they're determining whether there really is a FOCI issue, they'll look at these factors. And these factors speak to either the contractor, the foreign interest, the government of the foreign interest as appropriate. So for instance, the record of economic and government espionage against U.S. targets, that speaks more to the foreign government. Whether there's a record of enforcement and or engagement in unauthorized technology transfer, the type and sensitivity of the information that shall be accessed, the source, nature, and extent of FOCI. A very easy example of this is if a foreign person has a less than 5% interest in the company, I would think that that would be something that would be easily mitigable as far as DSS is concerned, because it's a minority, likely a very small minority interest that has no ability to actually control. Whether there's a record of compliance with U.S. laws, regulations, and contracts, the nature of any bilateral and multilateral security and information exchange agreements that may apply to the situation and to the foreign interest at issue, and ownership or control in whole or in part by a foreign government. So DSS has determined that there is a FOCI issue. Does that mean your company has no ability to get a clearance? No, that's not what that means. There are ways by which FOCI may be mitigated. And the easiest way to think about it is essentially the foreign interest needs to be cut off from the ability to control the company and the ability to access secured information. So some of the ways by which that's achieved is through a board resolution, for a corporation where a foreign interest is not entitled to representation on the board. So the foreign interest, if it's an owner, does not have a director. Then the company may issue a corporate resolution stating that the foreign interest will not have and can be effectively precluded from access to all classified and export controlled information. You can also put a voting trust agreement or proxy agreement in place by which the foreign owners relinquish most of their ownership rights to cleared U.S. citizens. And then DSS will also allow, as a means to mitigate FOCI, a special security agreement or security control agreement. There are templates of all of these, the board resolution, the voting trust and proxy agreement, the SSA, and the SCA available on the DSS website. But the SCA is used when a company is not owned or controlled by the foreign interest, and the foreign interest is entitled to representation on the company's board of directors, so there would be no access limitations put in place. And then the SSA is required when a company is effectively owned or controlled by a foreign interest, and then access must be limited. No matter what, the management of the company, subject to FOCI, but just in general, the management of the company must be done by individuals with PCLs who are also U.S. citizens residing in the U.S. DSS also provides for various plans that a contractor can put in place to further mitigate FOCI, and particularly FOCI issues that arise with affiliates of a FOCI mitigated company. So if a parent company is a FOCI mitigated company and now has a clearance, one of its affiliates could potentially be a subsidiary, and you need to put plans in place to eliminate the possibility that that subsidiary who does not have a clearance could access, for instance, classified information. So for instance, the affiliated operations plan addresses how business functions or teaming arrangements with affiliates of a FOCI mitigated company are not authorized unless a plan is in place and approved by the contracting agency and DSS. A technology control plan prescribes all security measures to ensure non-U.S. citizens cannot access classified information. The electronic communications plan outlines policies and procedures to prevent unauthorized disclosure to affiliates. The visitation plan outlines procedures for visitation between the FOCI mitigated company and its affiliates. And the facilities location plan, if a company is co-located with a foreign parent, where a company is co-located with a foreign parent, a minority foreign interest, or one of its affiliates, then this plan needs to be put in place as to how information is secured, classified information is secured, so the non-cleared persons or entity cannot access it. Well, now we are at the questions portion. So let me go back and see. Let's see. Michelle, we had one question. This goes to PCLs and the financial considerations and the credit report that often is part of the PCL process. What credit issues might cause an individual to be declined a PCL?
So that's a good question. So the concern that the government has with all these potential hang-ups in a clearance application is that there could be a conflict of interest where the applicant is put in a position where they're forced to choose between their commitment to the United States and their another loyalty, like to their self or their family or a friend. So in the financial aspects, the government might be concerned that you have a lot of debt, because then you may be tempted to sell classified information to be able to get money to repay that debt. I mean, if you just have a few late credit cards for a few $100s or something, that probably would not be a problem, especially if you're able to, explain it and show that you are on the path. Either the problem happened several years ago or that you have a plan in place to prevent it. But the big financial obligations, big debts, or a record in the past of not being able to manage your own finances would potentially be problematic.
Okay, we had another question. Someone said that it's taking an excessive amount of time for their employees to get cleared, and what could they do? And unfortunately, I don't think that there's necessarily any process in place by which that can be hastened and hurried up. I mean, do you know of anything where a contractor could help move that process along any faster?
Sometimes if you have a contact within the government, or if your FSO has a good relationship with someone within the government, there are ways to speed it up and get yourself or your employees put up higher in the queue, but sometimes it's just out of control. And I know within the past year, the government has had problems with data breaches and systems going down that have slowed down its process.
Okay, we had another question. Can an individual continue to hold a PCL if its employer does not have an FCL?
Yes. I actually have a clearance, and I do not work for PilieroMazza does not have an FCL. And in my past jobs, my direct employer did not have an FCL. It's typically done by entering a consulting type arrangement with the facility, the company that does have the FCL, and they act as your sponsor, and they are the holder of your clearance, but you're able to then use the clearance.
Another question was, what does NISPOM stand for? That's NISPOM. That's the National Industrial Security Program Operating Manual.
And if you Google that, it is available online. You can get a copy of it if you don't have one. As are the Doha guidelines. Those are also available online.
Someone asked, for a corporation to apply for an FCL, can we only have the FSO hold a TS, I think this is supposed to be TS-SCI PCL, without the president and CEO holding a PCL at the same level? And the answer to that is no. That the senior management personnel as well as your FSO all need to have whatever clearance the company is seeking for their FCL.
But if the FSO has a top secret and everyone else just has a secret and all the facility wants is a secret, that would be fine.
Perfect. If a U.S. citizen has children studying in a foreign country, could that present a FOCI issue? That would not necessarily present a FOCI issue, but potentially that would come up and would need to be disclosed in the PCL process.
Right. And if you look at the Doha decisions are interesting because you would think some countries would pose more of a problem than others, and sometimes that plays out. For instance, if your children were studying in a country that was known to be hostile to the United States, there may be a concern that your child would be, kidnapped or something horrible, which obviously you don't want to happen, and that would create a risk that you be put in a compromised position. But there are no per se unreasonable or problematic countries or good countries. United Kingdom could pose a problem, Israel could pose a problem, Iran could pose a problem, or they could be considered okay if you were able to provide a good explanation. So the key there is just disclosing it and then responding to any concerns the government may have.
I think, Michelle, you had touched on this, but the timing of the PCL process can take a couple months up to about a year. FCLs, I would say, might be processed slightly quicker, but of course they deal with the form is not over 140 pages like the SF-86 is for your PCL, but there are some pretty complex issues that could be involved, and that depends on the complexity presented by the contractor who's seeking the FCL. But I would plan on a couple months for the FCL to be processed.
You'll also need to account for time to get all the right systems and measures in place. You'll need to, have secured rooms and, containers to store information in. All that needs to be approved before your clearance can be activated.
And then someone asked if there is a newer version of the NISP other than what's online, and whatever you're finding online is the newest version. I think that 2006 date is correct. DoD periodically issues directives that kind of bring more clarity to the process, but the NISP is still the work from 2006 is the working manual that everyone refers to. I think that's all that we can. We're getting a lot of questions about the reciprocity between agencies. For instance, between CIA and DoD. For instance, can a full scope poly with NSA be transferred to a full scope with the CIA?
You would think it should be able to be. There's no reason why it per se can't, but as you all know from interacting with the government, sometimes an individual may take an unreasonable position. So what you can do is, put your security contact with the CIA in touch with your DoD contact, and hopefully they can provide you with the information they need. You may have to supplement your existing application or update your application, but the government does try to foster as much reciprocity as possible.
We had a really interesting question. If your company is under an SSA, can emails pass through a foreign located server? And I'm inclined to say no, because that would be potentially that a foreign interest could access those emails from the foreign located server. Another question was, what services does PilieroMazza provide to clients or potential clients for applying for the FCL? We can help with the full gamut. We can help, we can swoop in and answer specific questions as they arise. We can help mitigate FOCI issues before you even apply so that you can represent all of that to DSS. It gets a little tricky for us when we're dealing with PCLs. We do have clients who ask us for assistance with PCL issues, and generally depending on the level that the employee, for instance, if an employee's PCL was denied and they're interested in appealing, we have to handle those carefully, because obviously the PCL process can raise very sensitive issues for the employee. And if the employee is not one of those key management personnel or the FCO or FSO or an owner, we generally want to create a little bit of a barrier so that there's not a conflict for anyone down the road. In those cases, for the PCLs with employees who are essentially direct labor on contracts, we often work with lawyers at other firms and help clients connect with them for those specific issues. A copy of the presentation, I believe, is attached as a handout here. You can also access it at our website at PilieroMazza.com/presentations. And I think that's all that we can get to today. If you've answered, or if you've submitted a question and we have not answered it, we will email you and with follow-up, because some of these questions are, this whole PCLs and FCLs are so specific, either specific to an individual, specific to the contractor, that some of these questions are, we want to give you the one-on-one response that you need. So we will be emailing you a follow-up response to many of these questions. Michelle, do you have any other closing remarks?
No, I hope you all found this useful and informative, and we look forward to working with you and helping you with your security clearance needs. Have a good day.